I will then basically hand you over to Lord Justice Birss, who hopefully many of you will know. His resume was on the materials we circulated. He has previously sat and been extremely successful in the IPEC, and he did a great job there. And then he's seen rushing his way up the ranks. Now, just this year, early this year, February, I think, now in the Court of Appeal. He is doing far too many patent cases, being a Cat 4 or 5 judge, you see, unfortunately. We would love to have him more on trademark designs and copyright cases, so if you could kindly get those patent cases resolved, and then we'd love to have a few more specialist IP judges in our trademark cases. Not that we're complaining too much about the other judges, but we would love to have more of you, Colin, all right? So, on that happy note, I'll hand over to Lord Justice Colin Birss.
Well, thank you, Roland, for that kind introduction. And it's a real pleasure to be here in Taylor Wessing. It's always nice to be at Taylor Wessing. I did a lot of work at the bar for Taylor Wessing. Other law firms are available, though. But of course, the Brands Forum is a really good opportunity to talk about intellectual property, which is why I'm not going to do that. What Roland didn't mention is that, as well as being a member of the Court of Appeal from February, I was also appointed Deputy Head of Civil Justice. Which gives me a role that relates to civil justice as a whole and not just intellectual property. And what I was going to speak to you about briefly is what I call the future of civil justice. And what I'm talking about in particular is digitization, because it is coming and it's important. Looking at the court system today, you probably, if you litigate in the High Court, and probably the roles building, and so you think digitization's already arrived. But it hasn't in two respects. First of all, the CE file in the roles building is a flat file. It's just a digital file. And I'm not talking just about the idea that you can just put electronic documents online. I'm talking about a much more sophisticated digital system than that. And the other thing is that, believe it or not, the roles building is not the entire universe. There are county courts out there all over England and Wales. We have the district registries, which in fact do use CE file. But the county court in particular, which I care quite deeply about, not only because I'm Deputy Head of Civil Justice, but also because when I first became a judge, I was a judge of the county court. And it does matter to me. And it's important for the justice system as a whole in our country. It's not good enough simply to have super IT in the roles building and rubbish IT everywhere else. There is, I won't give you the long speech because Roland's right. Unfortunately, the timing means I am back in court at 2 and I've really got to go much sooner than I would like. But very, very briefly, the position today is a zoo. If you step behind the scenes in the court system, you will find a zoo of different IT systems, paper, all sorts of computer systems. They don't talk to each other, record keeping, some of it, paper, some of it, and it's a nightmare, is the truth. We are building an IT system. It's called the Reform Programme. It's well funded by government, and it's been going now for about 5 or 6 years. Again, if you're a litigator in the IP courts of the roles building, you probably haven't even heard of it. This might even be the first time you've ever heard anyone tell you. But we are building that system. It now currently allows litigants in person to issue small money claims online. And it allows legal representatives to issue damages claims, any claim for any damages online, and this is in the county court. What this system will do, however, which is very, very exciting, is, as I said, it's not just a flat file like CE file, and it will replace CE file eventually. The most interesting thing about it of all is that the computer will understand what state the case is in, and it will know what orders have been made, and it will be able to react appropriately to those orders. Now that has profound consequences for civil justice as a whole, including trademarks and IP generally, but civil justice as a whole. What it means is that the system will know, for example, that the judge gave directions that the evidence is due to be uploaded on a certain date. And the computer will know that, so that if it gets uploaded by that date, well, the computer will know it's been uploaded and will know that the next stage in the case is the appropriate stage. But of course, obviously, by contrast, the computer will also know if it hasn't been uploaded. And you can cut out very significant administrative work of not very exciting administrative work of people trying to look into paper files to find out what's happened. You can send an alert to a judge, you can send an alert to a member of staff. You might not even put a member of staff or a judge in the loop at all, you might conceive of a court rule, and we have rules like this already, which provide for automatic consequences for non-compliance with court rules. So you simply have an order that you have a rule in the CPR which says if they don't file on time, then you make an unless order that unless they file within 2 weeks, they'll be struck out. And the computer could do that automatically. And the whole thing could be done automatically. And that's just an example of the kind of thing, the power that these systems could have. And actually, it's a positive thing. Because the other thing these systems can do, and we're building all this stuff, is prompting people before they've breached the order to try and get them not to before they even do it. So instead of just making an order, which and we've done a lot of work trying to write orders which litigants in person will understand, instead of just making an order and expecting them to fail to comply with it, you make an order, the computer knows what date the evidence is due, and 2 weeks before that date, the computer sends an email to the litigant and says, remember, you've got to file your evidence on this date. We've already found that one rather simple bit of coding where we made the DQs, directions questionnaires, which is something that real people do in litigation. I don't know if you guys do directions questionnaires. I can't even remember whether you have directions questionnaires for trademark cases in the High Court. I'm so out of it. But in the part of county court work, directions questionnaires are really important, and they routinely don't get filed on time. And there is a cottage industry in the county courts of staff and judges and resource chasing up the filing of directions questionnaires. We need directions questionnaires because the judges can't give directions, until you've got the directions questionnaires. So, in our IT system, the litigants in person, they get, if you're a defendant, you get notified there's a claim, you go onto the system online, you can read the claim, it will then ask you questions, do you want to defend the claim or not? Assuming you do want to defend the claim, give you a chance to say what your defense is, interact with a timeline feature, which I'd love to tell you about as well, really, really interesting. And then before the litigant has finished, it then says, and here are the directions questionnaires questions. Please tell us how many witnesses you think you might want, all that sort of stuff. And it's only when they've answered all those questions that they get to the end of the dialogue and they get the chance to say, are you happy? Yes, no, effectively. And if they say yes, then it goes. So the directions non-compliance literally vanishes. The claimant then gets all the material, is told there's an alert, the claimant can see it all instantly. The claimant is asked, do you want to continue with the claim or not? You've read the defense, do you want to drop it? Many people do, but most don't, of course, but some do. And if they want to continue, then they get asked all the directions questionnaires before they get a chance to finish. And then at the end, okay, yes, no, if they're okay, done. So we've got directions questionnaires from both sides without anyone having to be chased and making it simply impossible not to comply. What we've had is cases that have gone from issue to being ready for directions in 48 hours, because the interaction is online. We've had a case that was tried in Guildford by one of the district judges who does this work, which went from issue to trial in 2 weeks, because it was done online. He'd given the directions, he realised it was possible and arranged it all, and it took place. Now, that matters a lot in the county court, but it matters to you too, because if we can make these transformational changes to civil justice as a whole, it will affect just as much. It'll affect trademark litigation, copyright litigation, IP litigation, patent litigation. Of course, I'm not saying that every trademark case or patent case can be tried from start to finish in 2 weeks. I'm not, I know that's, you wouldn't like that, you wouldn't know. I'll say something inappropriate about the way lawyers make their lives, but it will have these effects. And it's a really good thing. And I have got so little time, I'm going to stop there because I know it's an opportunity to ask questions as well. And I'd like to give you a chance. This is your chance. Play Put Off the Judge. So, and maybe win one of Roland's bottles of, what is it? It's, oh no, you don't want that.
You're right, one of them's the counterfeit lookalike.
But look, I could go on, but I think it's probably sensible to stop there. Thank you very much.
Thank you, Colin.
Any questions for Lord Justice Birss?
Really?
Really?
Doesn't have to be what I said. I can look after myself if you want to ask me about IP.
I have a question then.
Just don't ask about AI
Tim.
and computer inventors.
Tim.
Just about to ask, is there anyone looking at AI in terms of trying to predict decisions or make decisions?
Well, the answer is yes and no. So it's obvious that a use of artificial intelligence, sort of machine learning type artificial intelligence, because at one level the computer knowing how the state of the case is a kind of artificial intelligence in a funny way anyway, but machine learning type techniques, a place where we've at least identified that it would be interesting to try, isn't to do with deciding the case, but to do with triaging cases to send them down the appropriate handling route. Because if you were able to say, the machine learning was able to recognize a pattern which said this is a case which won't settle, we can send it to a judge quicker. But if it's a case where you think actually there's a 80% chance that this case will settle if you leave it alone for 2 weeks or 3 months or whatever, then maybe, so there's a resource allocation possibility. Now, no one is actually doing the work on that now, but we've identified that that's a possible thing we could do. As far as using AI to actually make decisions, I'm not aware of anyone who's doing that, and certainly not in our system, but it's obviously something that people talk about, no question. And another place which we're certainly talking about seriously which again is sort of borderline machine learning AI against sort of wider AI, is ADR. Because one of the things which this system will allow you to do, and we certainly want to do this, and we're talking about it in detail, is effectively build dispute resolution, alternative dispute resolution, into the whole process. So instead of just having a civil case go to a certain point and then, ta-da, today is the day you're going to be seeing a mediator or whatever, what you do is you could imagine a situation in which the system is clever enough, perhaps using machine learning, to have a view about when the best moment would be to suggest that the parties mediate. So that's something we're certainly looking at, because if cases can be settled, and especially in civil justice, then it's much better for everyone.
So I have a question, which is your automated process of pushing the case along, I think for us it's less familiar territory, because actually we tend to comply, I like to think.
I'll remember that.
Yeah.
From Taylor Wessing.
But I can see I can see how beneficial that would be, and it's a sort of more interventionist court in a way. Do you think that there's an appetite for being more interventionist, for example, in ADR, so actually sort of telling people, right, go away, I actually don't want to see you because I think, for now at least. Or alternatively, going, actually, I'm going to give you, here's a preliminary view, because the UK IPO used to have it and stopped, and now it's bringing it back in again, or at least debating that.
Well, sorry to cut across you.
That was it. Do you think a judge's preliminary view and go away and have an ADR session might actually get rid of quite a lot of
Well, I think the answer is yes. Again, if you step out of the world of the IP in particular and look at the world across the piece in civil justice, the Civil Justice Council, which is a sort of consultative body that sits alongside the Rule Committee, has just published a report, a really interesting report, just 2 months ago. Terry will look at me and tell me if I got it right or not, but about 2 months ago, on bringing ADR more into the civil process, and in particular on making it mandatory. Because a big issue is whether, and there's different kinds of mandatory. There's mandatory in the sense of a judge ordering you to go to a mediator. That's one thing, maybe right, maybe not in an appropriate case. But one of the things that which we're very interested in doing and are looking at very hard is making a free mediation step, which there is already free mediation for small claims in the county court. And so it doesn't involve putting the parties to cost. But having a free mediation step as simply one of the steps in the process. So it's mandatory in a sense, but it's sort of soft mandatory, if you see what I mean. You just get to a point, you put in your claim, you put in your defence, and the next thing you have to do is see a mediator. And you do that. And that's something which, again, we're very interested in, because if it can help people resolve their disputes, well, that's actually what the point of it all is. So yeah.
Okay. Any other questions? Yes, Alice.
What do you think are the main difficulties that need to be overcome on the kind of road to digitisation?
Wow. Okay, well, there is, I can tell you, the difficulty, the biggest difficulty is change management. And that's not one part, but not all of it, is managing judges and helping them see the benefits of what's coming and giving them appropriate training and all of that. But it's not just the judges, there's obviously staff, but also, frankly, lawyers. I mean, and from my point of view, that's one of the reasons that from my point of view, having these conversations with you is really, really helpful, because you need to know that this is happening, but to some extent, people like me need to persuade you that it's worth it. The change management thing it can be quite hard. People are very conservative. I mean, small c conservative. And I get that, because from a litigation standpoint in particular, there's always a fear that you might do the wrong thing and get it wrong, and that's very understandable. But we need to change the way we do litigation. Litigation is too expensive. And if I put in my plug for why can I stand here in a big multinational law firm and tell you litigation is too expensive, the answer is because you can just do more cases. You don't have to necessarily have a business model, which means you do one mega case per whatever, year, 5 years, and make a fortune out of one case. The lesson of IPEC is that it's possible to have a successful legal practice just doing more cases. So I'm an evangelist for saying the cases should cost less, but don't worry, you'll still be able to pay the mortgage. You just have to do more of them. And the demand is there. The other thing, get me going now on IPEC. When we reformed IPEC, some very serious people, I mean, as in thoughtful people, quite sort of thoughtfully were putting forward the view that there was no demand, that there was no problem of access to justice for small intellectual property cases, because we weren't seeing all these small intellectual property cases. And I think the most important lesson that comes out of the IPEC reforms, which applies across the board in civil justice, is there is demand. There are loads and loads of disputes which just do not get anywhere near a court, which should, because it's not fair if you've been diddled by someone, they've taken your money, whatever it is, and people don't take them to court because the court system as a whole is too big and cumbersome. So that's my view.